So the California magazine, assault weapon, and ammo restriction cases recently had a hearing before Judge Benitez in the state of California, and a lot of you are asking what happened. So let's talk about this. But real quick before we jump into this video, if you think the state of California needs to stop violating our rights to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. How's it going, everyone? My name is Anthony Miranda. I am a licensed practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level, while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide you any legal advice, but instead to give you greater insight into the inner workings of Second Amendment litigation and help you understand what's currently going on in the battle for our right to keep and bear arms. As I mentioned in the intro, in this video we'll be discussing three cases: the Duncan v. Bonta case, the Miller v. Bonta case, and the Rhode v. Bonta case. These cases are challenging the state's ban on so-called large capacity magazines, their ban on so-called assault weapons, and also their ammunition restrictions, which are in place in the state of California. Now, I'm not going to go through all the procedural history of all three of these cases. If you want that, you can watch some of my prior videos where I go more in depth on those. What you need to know for this video is that these cases have all been heard in their own way. They've all made their way up to the Ninth Circuit, various levels. The Duncan case, in fact, made its way all the way up to the Supreme Court. And all these cases eventually made their way to the Ninth Circuit because a judge in the Southern District of California named Roger T. Benitez originally found that these three cases and these three issues, the magazine ban, the assault weapons ban, and also the ammunition restrictions in the state of California, were all three unconstitutional. After the Supreme Court issued their decision in the landmark case New York State Rifle and Pistol Association v. Bruin, these cases were remanded back down to Judge Benitez to the Southern District of California for him to reconsider all three of these cases in light of their ruling in Bruin. One of the primary reasons for the remand of all of these cases was because the Ninth Circuit's prior use of something called the two-step approach and the use of interest balancing, which was recently expressly rejected by the Supreme Court in that Bruin decision. In reaching their decision in the Bruin case, Justice Thomas, writing for the majority, stated that, "Today we decline to adopt the two-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if a firearms regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command, that unqualified command being shall not be infringed." So after the Supreme Court's decision in Bruin, the analysis to be considered in all these major Second Amendment cases is no longer the two-part approach, no longer interest balancing, but instead it's a simple test, what Judge Benitez called prior the simple Heller test, which is simply text as informed by relevant history and tradition. So these cases in California are starting kind of over once again, but Judge Benitez is trying his best to essentially streamline these cases and to get them resolved as fast as possible. In the Duncan and Miller cases, the state of California has been making multiple attempts and have been arguing to Judge Benitez that the state of California needs even more time, that they need at least until kind of mid next year is what they've been arguing. But Judge Benitez has rejected all of those attempts, and he's tried to streamline these cases as fast as possible, but that essentially has not prevented the state of California from continuing to argue and kind of threaten Judge Benitez that they will try to raise some sort of procedural issues because they believe they need more time to find the relevant history and evidence that's required under Bruin. The state of California's arguments for why these cases need to be pushed out even longer and why they need more time is essentially because they're arguing that history professors are the only ones who are qualified to do the type of analysis required under Bruin to look at the relevant history and tradition. And they argue that these history professors that they need, or maybe the ones that they want, have teaching requirements, that they're very busy, and maybe they don't have enough time to review all the relevant history that would be needed. And so they're saying, well, we want these specific history professors. We believe they're the only ones who can do this job, and therefore we need a ton of time to get these left-leaning, likely liberal state of California history professors to look at some sort of historical evidence, to put forward some sort of historical evidence that could maybe even support the state of California's bans, because as of right now, the state of California has not really presented any historical support for what they're doing. And all of this essentially came to a head this week. A lot of you are familiar that at the beginning of this week, 3 of these cases, actually a little bit more than just these 3, but a lot of you are asking me about these 3 main cases. These cases came before Judge Benitez, and there were hearings before Judge Benitez on the Miller case, the Duncan case, and the Rhode case. What ended up happening at the hearing, and a lot of you have been asking, was that Judge Benitez gave the state of California 30 days to present a spreadsheet to him of all enacted laws and regulations which the state of California argues actually supports their case at hand. Like I mentioned under Bruin, relevant history dating back to 1791 is what the state of California must provide to the court in support of what they're trying to do with these laws. In his order, Judge Benitez told the state of California that the latest laws that they could produce would be those including up to 1888. Now, some of you may be asking, why did he pick this arbitrary time period? And it really is an arbitrary time period. He just picked 20 years after the ratification of the 14th Amendment. But he did say that the only thing he's really going to consider, and the ones that are going to be most important, are dates surrounding 1791 or history surrounding 1791, because that is the actual relevance. But maybe he's giving some buffer to protect his decisions, and he knows the state of California is going to appeal to the Ninth Circuit and say that there's maybe some procedural issues. They should have been allowed to provide other evidence at other time periods. Now, although he did permit a little broader time period under this order for the spreadsheet, he still stated at the hearing that he would only primarily consider examples around 1791. So Judge Benitez ordered the state to put together a spreadsheet of all the historical evidence that they could find within the next 30 days. Then the plaintiffs in this case have 30 days to rebut those examples that are on the spreadsheet. And then after that, there's going to be 10 more days for replies. So essentially the case here, all these cases will be in the queue at least for another 70 days. The state of California wanted even longer. Like I mentioned, they wanted until like mid next year. They've argued for that multiple times. But currently, Judge Benitez gave them only 30 days to come up with additional evidence, plus some additional days for responses as well. Now, some of you may be asking, why did Judge Benitez ultimately do this? And really the best answer I have for you is that he likely did this to mitigate some of the arguments, like I mentioned, that the state of California has already teed up and will likely try to make on appeal. The state of California has already signaled multiple times that they will try to argue to the Ninth Circuit that there were procedural errors in this case, that Judge Benitez committed some sort of procedural error, that he should have given them more time, should have allowed them to have more time for history, should have allowed in other expert witnesses, other things like that. So I think what this did is help to mitigate some of those arguments that the state of California has teed up and will likely try to argue to the Ninth Circuit. So that is my best explanation for why Judge Benitez did this. So that's what happened at the hearing for all of you who have been asking me. That's where these cases currently stand. If you have any questions, go ahead and comment down below and I'll try to answer best my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algor's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impact this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.